Hello Esmeralda, my name is Melanie Frempong and I'm a trainee solicitor and a trained mediator here at Bodge, Stodge and Hassel. I'm going to discuss with you today the process of mediation, its advantages and in particular its advantages in relation to your ongoing dispute with Mr. Skydiver. Mediation is a form of alternative dispute resolution. As a mediator, I will assist in resolving the dispute on hand by reaching a suitable agreement without the need of litigation. I'm here not to judge, advise, or represent either party, but simply to act as an impartial facilitator. I'm going to start off by explaining to you the process of mediation. Firstly, this begins with an open phase. This requires me to meet with both you and Mr. Skydiver. At this meeting, I will try my very best to make both parties feel at ease, possibly by referring to each other on a first name basis if appropriate, and explaining to you the confidential nature of the mediation process. Both parties will then be given an opportunity to present their case. This is to be done without any interruptions. Any objections is encouraged to be written down and disclosed or discussed once the speaking party has finished. Next, we have the negotiation phase. I will arrange a private, separate meeting for both you and Mr. Skydiver in order to explore the issues experienced by the both of you and in greater depth and in an attempt to identify common ground and areas of compromise. I will move between both parties. This allows you to openly discuss the issues and possibly understand the other person's views if they decide to disclose it in a non-hostile environment. I will then guide both parties towards the settlement phase, which where I will take both proposals made by each parties in an attempt to find a compromise and on a negotiated settlement. This will then be drafted by me and be signed by both of you, thus making a binding contract. The general advantages of mediation are as follows. It is quick and easy and a more cost-effective way of resolving a dispute. It is also flexible as we're able to deal with not just the legal matters such as the boundary disputes, but also the non-legal issues you are currently experiencing. It is also informal and confidential. Informal, so is in a relaxed manner and as opposed to court. It is also confidential, impartial, and without harsh judgments. Even without an agreement being made, materials or any information disclosed in our mediation sessions are completely inadmissible in court and cannot be disclosed to any third party. Also, any individual discussions I have with either party, I cannot disclose with the other unless I'm given express permission to do so. The mediation is also not compulsory, so therefore, if need be or if necessary, each party is free to leave if they no longer want to participate. Okay, now I'm going to tell you, Esmeralda, the advantages in your particular situation. It's always a good starting point to say that even though it feels as though you and Mr. Skydiver are finding it difficult to agree on matters, that a mutual decision to join mediation is always a good starting point because you've both willingly made a decision to resolve your issues in a calm and rational manner. Also, I must ask you, Esmeralda, that is 30 centimeters difference in your land, that detrimental to the value of your property. A long and costly litigation process over the disputed land, will it add value to your property? As a matter of fact, the answer is no. Court proceedings regarding boundary dispute may actually reduce the value of your house if you decided to sell it. You have a duty to disclose the nature of any neighbouring disputes, which may, as a result, make your potential buyer hesitant, as they may want to avoid living in a property involved in a dispute with a potential neighbour. As you only have general boundary lines, this is very difficult to determine the legal boundaries. A number of cases have highlighted the difficulties in this and the lack of clarity and the inconsistent approaches that courts have adapted in determining legal boundaries. Lord Hoffman in the case Allen and Wimbley versus Inslee 1998 emphasises the cost and evidential burden on parties brought by boundary disputes. Title deeds, even though you may have this, and land registry plans only starts as a mere starting point in a great, lengthy and costly litigation process, which may need you to hire experts such as chartered conveyors and able to determine your boundaries. In another case of Bradford and James, and it was held by the judge that an attempt of mediation should always be made right at the beginning of disputes before things turn nasty and become very expensive. In addition to this, the cost becomes an aggravating factor which heightens the issues and animosity already at hand. In 2009, a case Tuxton and Collins, £40,000 worth of cost was allocated to each party in determining legal boundaries. Also, your non-legal issues that you're currently experiencing are also dealt with in mediation, whereas the courts are not generally concerned and with non-legal matters and are only focused on the boundary disputes. So therefore, mediation will allow you to mend and possibly return to the relationship that you had prior with Mr. Skydiver prior to the issues on hand. So I would encourage you, Miss Esmeralda, to consider mediation as it will be very beneficial to you. Now that the agreement has been drafted, I'm just going to quickly highlight to you what it consists of. I've outlined the issues raised to me in our mediation sessions and included the terms that we agreed to, such as that Mr. Skydiver is to play his music in a considerable manner, so if possible doing so while his window is closed, and in hot weather conditions or in cases where he has to open his window, keeping the music at a reasonable volume and playing it at reasonable hours. He's also to try to put any leftover food in a bag before disposing it in the main bin outside, and also making sure that the bin is fully closed. Esmeralda is to inform visitors to avoid parking in a way which obstructs Mr. Skydiver's driveway. Also, she's to try very hard to control her dog and to keep a constant eye on him to ensure that he is not on Mr. Skydiver's property. And if she finds difficulty in doing so, she is to hire an expert dog trainer to help her in doing this. If all of these conditions are met, Mr. Skydiver will not erect the fence. As discussed in our mediation sessions, the boundary disputes started as a result of these non-legal issues that's been ongoing between yourselves. So I would seriously encourage you, Miss Esmeralda, to sign the draft, as it will then become a legally binding document. So therefore, you'll both be bound by it. And if you adhere to the terms, Mr. Skydiver will not erect the fence. So therefore, you're able to continue the relationship you had prior to the issues, and you do no longer need to worry about your back problems increasing as a result of the proposed erectal of the fence. So I would seriously encourage you to sign the draft, Miss Esmeralda, and I hope to hear from you soon and hope everything goes well for you. Thank you.